So what we're going to do is we're here to expose it, let people tell their story, and let everybody in the public see the horrors of the court system in Suffolk County, New York.
Long Island Backstory with Chief Correspondent Gary Jacobs.
Good evening, I'm Gary Jacobs, and welcome to Long Island Backstory, where we tell the stories and news that you won't see in the traditional news media here on Long Island, controlled by the Newsday, Cablevision, Altice monopoly. This is really, my next guest today is a law guardian or attorney for the child, and this is really the reason that I started doing Long Island Backstory, and I've expanded into a lot of other things that I'm interested in, but this is really one of the things that I'm very interested in, and I've been wanting to have a guest of his caliber on the show for a while, and I haven't either found the right one or had one that had the balls to be able to come on the show and talk about the system. So my next guest is attorney Stephen M. Burton. I first met Mr. Burton about a year ago as the president of Americans for Legal Reform. We do a lot of advocating for people who are being wronged by the system. And we were advocating for a father who had an order of protection issued against him, ex parte, meaning he wasn't there to present his side of the case when the order of protection was given. His ex-wife got one against him. We believe that it didn't rise to the level of an order of protection. In fact, nothing was done wrong there whatsoever. Actually, the wife was wrong. But the man was dragged through the ringer for months, and this time that he had the order of protection, he wasn't able to see his son, and this dragged on for almost a year. He missed birthdays, he missed Christmas, and the judge just kept adjourning it and saying, I felt there's an order of protection. Finally, that judge was removed from the case. We got another judge, and who we know is a much fairer judge, but we were set for trial. We walked into the trial, and my next guest, Stephen Burton, was the newly, not appointed, but he was filling in for another law guardian. He was the law guardian on the case, and he came in and he actually did the right thing. He read the petition, realized that there shouldn't have been an order of protection, which any legal person would realize, and he said as much to the judge when the judge asked his opinion. When we left the trial, some other watchers were there, and they said, wow, I got to get this guy's number. He's a great attorney. And I thought to myself, well, why is he a great attorney? All he did was the right thing. But I realized it's so rare that an attorney does the right thing, stands up to the court, and says, I don't care what anybody says. This is the right thing to do. I asked Mr. Burton for his business card, and I read it, and I want to look for and on his business card, it stated all the types of law that he practices, and I'll get to them in a second, but it said in bold letters, no divorces. I said, this is an interesting guy. I've never seen that, because there's a lot of money in divorce. So let me just read a little bit about Mr. Burton's experience, and then we're going to introduce him. Mr. Burton is a graduate of Purdue University, former Suffolk County Assistant District Attorney. He's a litigation attorney, which I'm going to talk about in the show. That's something different than your everyday attorney. A lot of attorneys settle everything out of court. They never have to litigate. Not good. You want an attorney who's capable of litigation in case it needs to go that way, because all the attorneys in this small family of attorneys on Long Island, they know which attorneys won't go to trial and which ones will if they don't get their way. He handles criminal law, accidents, personal injury, medical malpractice, DWI, orders of protection, and family law other than divorce. So, Mr. Burton, welcome to the show.
Good evening.
First of all, let's explain to the people who are watching what is, and I'm calling it a law guardian because that's really what people still refer to it as. The correct term now is attorney for the child, but I'll call it law guardian because it comes off my tongue easier.
Well, depends on what state you're in. In New York, the attorney for the child are appointed so that they protect the interests of the children. Try to get an unbiased view. Frankly, we don't have to believe either of the parents. We make our own judgments. We do our own investigating. We speak to our clients. We advocate their desires. And we try to protect them as best we can.
Why do we need that? If we have, shouldn't the judge do what's in, they say family court, we do what's in the best interest of the children. Shouldn't the judge know, or a psychologist know what's in the best interest of the children? Why do they need an attorney?
You know, it's kind of funny you ask that, because when I started doing divorces in 1981, and I did them for 3 years and couldn't stand doing them, they didn't have attorneys for the children. They didn't really exist back then. So, you know, a lot of things have changed and a lot of things have come in since then. I don't think it's fair to put a judge in a position where they have to be the one who interviews anybody outside of court. And, you know, they just don't have the time, and you don't want to make them a witness.
Right.
You know, so it serves a good purpose.
Because now it's become automatic. They almost every divorce, I don't know, I'm saying almost because there may be some that don't, but almost all the time they appoint a law guardian in the case.
If there's a custody issue.
Yes. Custody, right. Yeah. Well, even domestic violence issues, orders of protection, I see them, if the kids were present, they...
Well, that would be CPS getting involved, and that's a whole different ballgame.
Right. Well, that's another horrific thing. You know. That's another show right there. Let me ask you, if somebody doesn't want a law guardian, do they have a say in the matter? If the judge says, hey, I'm appointing you as a law guardian.
Are we talking about in a divorce? Or
in a divorce case. I mean, that's really more of my expertise. So in a divorce case, you go into court, both parents say we want custody, and the judge says, I want a law guardian, and you're paying him $75 an hour out of your own pocket, maybe split 50-50, maybe one party pays, and you say, you know what, I don't want it. I don't want my kids having an attorney. I want to leave them out, and I want to fight with my spouse in court. Can you stop in a
It really
law
depends
guardian?
on what the allegations are, to be frank. I mean, most judges prefer it. Depends on the age of the children. You know, if the child's 6 months old, you know, versus 6 years old, I mean, that's relevant. It really depends on the age of the child and really how bad the allegations are.
Well, what if there's they're just going to court and fighting for custody?
Again, depends on the age of the children. I would say that in most litigated matters, a lot of times a judge will wait until they see if they can settle it. Right. And if they can't settle it, then they appoint the law guardian.
How do law guardians get appointed or assigned? How does that work? Because I often make fun of some of these attorneys who run around the courtroom. I call them ambulance chaser lawyers, who run around and sit there in the court when they have nothing to do, and they see a divorce going, you know, hoping that the judge sees them. And I've seen them say, oh, we have XYZ in the courtroom today. Let's appoint them as a law guardian. What is the real procedure?
It really doesn't work that way. I mean, on the private pay ones, the judges decide who they want to choose, or sometimes the attorneys for both parties sit down, they say, you know, we'd like to have so-and-so. We have a good experience with so-and-so. With respect to the family court aspect of it, you have people in a rotation. So they have days with the intake. So that's why you may see them sitting in the courtroom.
Right.
Because they're mandated to sit in the courtroom, and they are supposed to get the assignments of the day unless they have a conflict.
So just to explain, the difference in Supreme Court is usually the judge would appoint it, but the parties are ordered to pay for the law guardian. In family court, usually the state, I guess it's a state who pays, or the county, somebody.
The county reimburses the state,
okay.
But it's through the county law. But there are times when the family court can issue private pay rates to law guardians.
So, this is a common question that comes up. Is the law guardian supposed to do what's in the children's best interest or what the child wants?
Well, that's been an issue for the last 5 or 10 years. The short story is what the child wants. Right. If it can be done safely. If I feel, based upon facts that the child may not know or understand, that the child's in imminent risk of harm, you know, I can overrule it. But 99% of the time, I follow the desires of the client, right. And that's what the rule is. Because
what makes me nervous in this, Steve, is that when you meet with the divorce lawyer and people don't know what it, you know, if they've never been divorced before, they have no idea what a law guardian is. So they go in and the lawyer says to them, well, they're going to do what your child wants. And what makes me nervous, and I've seen an uptick since it changed from doing what's best for the child, I think it was 5 or 6 years, maybe even longer ago, where it became you do what your client wants, you advocate for them, an uprise in parental alienation because you need to win over that kid to tell the law guardian what they want.
You know, I've been doing this 37 years, and if I recognize parental alienation, I take care of it.
But what can you do?
I factor that in.
Because I've seen many times, and listen, if a kid's an alienated, they're going to say, I want to live with mom if mom's the alienator. If dad's the alienator, I want to live with dad.
If it was so simple as to ask them where they want to live with, if that's all I ask and that's all I probed, I wouldn't be doing my job.
But a lot of...
In other words, I'm a former prosecutor. I know how to ask questions.
Right.
I know how to ask them in different ways to get the, you have to basically spend some time and get the right answers.
But unfortunately...
And get to the truth.
Right, but you're trying to get to the truth. What I've seen in a lot of cases, and what this isn't you, because obviously you did the right thing in your case, but too many times I've seen law guardians, the first thing they do is when they meet with the clients, the children, they say, who do you want to live with? And this happened in my case, and it was a big problem because then the law guardian comes out and goes into court, and the open court says, well, the judge says to them, what do your clients want? They say, well, Judge, the young boy wants to live with his father, the young girl wants to live with the mother, or they both want to live. And now that parent says, oh, shit, I better work on these kids so that they don't say that anymore. And they go back to the kid, even though they're not supposed to, and say, why would you say you want to live with Dad? Or why would you say, it really, really, to me, that's abusive.
Well, I'm glad you had a good experience with me.
I did have a good one with you.
Certain people haven't. Okay.
Well, listen, you can't make everybody happy. So
no, and when you did the introduction, I would say that almost every judge, if not every judge in this county, is very, very responsible, and that's my opinion. I mean, we can differ and agree to disagree on that.
Well,
but as far as
disagree, but I won't do it.
Right, but
because you're on the show with me, I don't want you to.
No, but as far as the alienation, as far as people asking what the kids want, that's all factored into having somebody with experience to see through that.
But is there enough training? Because I don't think there's enough training in the law guardians. You have experience because you have real life experience in criminal cases, and trying cases.
Well, that gets into the whole issue of people that have never had kids on the panel versus people who've had kids on the panel. What your life experiences are. Obviously that plays into it. But you still need to be able to look at the kinestics, the body language of the child. You have to look at the way they're saying it, whether they sound like a puppet, whether they've been programmed, whether or not they're spontaneous, whether they're relaxed. I mean, these are all things that I look at.
Here's the part that I try to use, and I rarely see this part used. This is from the rules of the law guardian, and I'm going to read it. It says, when the attorney for the child is convinced either that the child lacks the capacity for knowing, voluntary and considered judgment, or that following the child's wishes is likely to result in a substantial risk of imminent serious harm to the child, the attorney for the child would be justified in advocating a position that is contrary to the child's wishes. In these circumstances, the attorney for the child must inform the court of the child's articulated wishes if the child wants the attorney to do so, notwithstanding the attorney's position. I don't see that used often enough.
Again, I said a few minutes ago, you got to use that sparingly at the right times when it's needed, when you actually feel that that's a circumstance that needs to be addressed.
Right. So. Another rule, it says the attorney for the child is subject to the ethical requirements applicable to all lawyers, including but not limited to the constraints on ex parte communications, disclosure of attorney-client confidences, and attorney work product, conflicts of interest, and becoming a witness in the litigation. This happens all the time. How does one stop it? Meaning, I see law guardians testifying all the time, and they basically become a witness in the case, and they give their opinion as to, many times the judge will say, well, law guardian, what do you think the parenting schedule should be? And I don't think they're not in the right place to do that.
That's usually done in chambers, not in open court. That's normally done when you sit down in the chambers and you have the two attorneys and the attorney for the child all together. And if there's a dispute, maybe between the two attorneys, judge may turn around and say, "What's your opinion? How do you think they can resolve that portion of it?"
Right. But I think too often though the judge puts that on the law guardian and seems to follow what the law guardian says. But many times the law guardian gets the signal from the judge which way they want to go.
I'm not sure of that. I mean, I think it's more they send them out for forensics, as you know. They send them out for different behavioral psychologists, and they get input from them, depending on how difficult the case is. I mean, most cases, the parties realize, or by the time it's over, they realize that both parties get visitation, whether you're the custodial parent or not.
Right.
You can't just shut somebody out.
Well, they can try. They can alienate them.
Some people do.
Yeah. One of the problems that I see often, and again, in Americans for legal reform, people come to me with problems, and one of the problems is the law guardian becoming aligned with one parent. Maybe it's the person, maybe one person got an order of protection, and let's say the children are living with the mother. She's the one who constantly takes them to the law guardian. She talks to the law guardian. They only hear one side, and it is a problem where the law guardian gets aligned. Listen, you're only human. You may like one or the other. Your case that I was familiar with you with certainly didn't happen because you didn't even meet either one of the parties before they walked in, and maybe that's why it went so. You had no preconceived notion.
I walked into that case an hour before.
Right.
Basically, I just was told I'm going to try it, and I tried it that day. But you got to be careful. The first person you talk to and hear their side of the story, you're going to get biased.
Right.
That's just natural.
Human nature.
Well, yeah, it's human nature, and somebody who's mature and experienced realizes that. It's like it's the last person you speak to. You remember that also.
Right.
Okay, so you're not supposed to be swayed by the parents.
But what can somebody do if they feel it's happening? And many times you don't want to seem forceful and say, I want to call the law guardian and get my side in. What is your advice to somebody who feels their other person has been aligned with the law guardian?
Well, again, I, as an attorney for the child, rarely ever talk to any parent.
Interesting.
And when I do, I have written permission or verbal permission on the record to do that from their attorney, because I won't do it without that. And basically, a lot of times I'll say to them, if you want to call me, it's at your peril. You can leave me a voicemail, but I won't call you back.
Right.
Yeah, I'll listen to what you have to say. I'll take some notes, but don't expect a call back.
And you need to teach some of these other law guardians, because I can tell you from experience that's not the way. In fact, in my case, it was a matter of who would get to that person first, and it was really a bad situation.
And you wonder why I don't do mats. But
I don't wonder why. I understand why you don't do them.
Regardless of how much money you get paid doing them, I won't do them. But you're speaking about a whole nother issue of who's paying the law guardian. That's a whole nother ballgame.
Right, absolutely.
Okay? If you have one spouse paying 100%, the other spouse paying 0%, the perception is, who is that person going to align with?
Right.
And frankly, you have to have the fortitude and the legal ethics to not align with anyone.
Well, speaking of alignment, another problem is, listen, all the attorneys here on Long Island, most of them, especially in the field of law guardian, of family law, know each other. So there's probably going to be a good chance that you have a relationship with one of the attorneys, or maybe both of the attorneys, and that tends to be a problem too. You can't help it if you're friends with somebody and you're going to have we see them do it. They talk in the hall. They have ex parte communications, and to me, that's another problem. I don't know what to tell people to do about it.
That's not necessarily ex parte, but that does raise another concern that I've voiced before. And I've spoken to some of the judges about that, saying that there's a perception, and I know the perception you're speaking about. If A and B have cases in common,
right,
and they appoint the attorney in one of their cases, their adversary, as an attorney for the child in a very lucrative assignment, therefore, the perception maybe that they're not going to be completely on the up and up, okay?
Right.
And I've always said to these judges that I'm a good choice because I don't do divorces, so I can't be put in that kind of conflict position.
Right. It is a great.
Whereas I can't even remotely, nobody can even remotely begin to accuse me of that,
right,
because I don't do it, and I won't do it. I'll turn down every divorce.
Right, and as you said, even if there's an appearance of impropriety, when we're talking about kids, you don't want that.
Well, I'm saying
because I would be uncomfortable with it if I saw my law guardian talking to my adversary, my ex's attorney, and I found out that they had cases in common. I would be uncomfortable with that.
Right, but you may be, but the bottom line is there's nothing wrong with me speaking to the other attorney about anything related to the case or anything that's not related to the case. We can talk about college football for a while,
Right.
I mean, it doesn't mean that there's a bias going on. And a lot of people, and that's probably why most matrimonial clients fire their lawyers all the time.
Several
because
times.
they don't trust them.
Right.
And it's very aggravating. It's very aggravating, and it's a very difficult area to practice in.
But I don't think that there's enough training in the law guardians. You mentioned these rules that you try to follow, but I can tell you a lot of people don't follow these rules. They talk to people, they get aligned. Aligning is a big problem because, listen, whose side are you going to, everyone's worried that someone's going to take the other person's side. But another problem is judges being friends with the law guardian, and sometimes the law guardian will do I call it the dirty work of the judge. The judge will let it be known, hey, I don't like the mom, I don't like the father. And the law guardians, it's hard for a law guardian who's appointed by the judge to stick up and say, no, I disagree, Your Honor, you have this wrong. They tend to, from what I've seen, and you may be different because I've only seen you in one case and the judge didn't let either anybody know he went in with I think he did a great job and went in with a clean slate and didn't care what happened in the other courtrooms. But many times judges do have opinion. They don't like one of the litigants. They've already made up their mind, and it's rare that a law guardian will go against that.
Well, I've never seen what you're saying. I've never seen a judge do what you just said.
Right.
But mind you, I only handled a handful of the private pay divorce ones.
Right.
Okay, I do mostly the family court ones, which are not. Okay,
right.
So I don't see
Well,
what
would
you're
you recommend? Let me ask you this, Steve. Would you recommend somebody, if there's going to be a law guardian, going into family court rather than taking the chance in Supreme Court?
It depends. I mean, we've spoken about that before, my colleagues and I, about the pros and cons of going to family court for the custody issue first.
For custody.
Because you're going to get a much quicker resolution.
In family?
Yes. Yeah. Generally speaking, you get a much quicker resolution, a lot less money spent. And usually you get the same outcome you would get, or maybe a more favorable one. I don't know.
Right.
But again, you have to understand that in the family court, these things are litigated quicker.
Right.
Yeah.
But we could probably have a whole show about the pros and cons of either of family court. I don't know the answer myself. People ask me often, what do you think is the best place to go? And I say, well, family court's the Wild East. They don't follow rules. A lot of the times they just do whatever they want.
Well, that's only because some of the attorneys either don't know the rules of evidence or don't follow them.
But they don't care because they can get away with it. Nobody's stopping them. Like, you're a criminal attorney. You're a rule follower.
Well, there are some superb trial lawyers that are law guardians, okay? And there are some that are not, okay? And, some people just are not going to make objections, and other people will be more aggressive.
I find criminal lawyers are. I've come around, and you and I spoke about this too. When people get an order of protection against them, and I tell them, first, an order of protection, they downplay them because they give them out like candy in court. So people are so used to them. Don't worry about it. You know what? And they don't want to try them. So the judges put pressure on people to just sign an agreement saying, look, just say that you're not saying you're guilty, sign the paper, consent to it. You don't like your ex anyway, you're going to stay away. But when you do get these, they just follow you, and then they say, well, he pleaded guilty to an order of protection, it gets used against you. So I say fight them from the beginning. But many family lawyers do not know how to fight them in court. And I say hire a criminal. If you got one, get a criminal attorney or somebody who can litigate criminally and follow the. It is quasi-criminal.
Yeah, but let's speak a second, okay? A lot of your quote criminal attorneys don't try cases.
Right.
Okay. So a lot of them just take pleas and never try a case in their life. Okay. So you need somebody who litigates.
Right.
And in addition to that, you need somebody that knows what they're litigating in these. So if you got an Article 8 family offense that you said you give out like candy, what you mean by that is they can come into court by themselves, make up a story, tell the judge a story, and the judge has nobody to refute it, and he issues a temporary order of protection subject to a hearing.
Right.
So you go and you got to hire an attorney. Well, that attorney has to know what's in Article 8.
Right.
I can't tell you how many attorneys come up to me and say, what do you think of this? And I'll say, well, drugs and alcohol, that's not a family offense. So but if you don't know that, if you don't know what Article 8 of the Family Court Act says, what enumerated offenses there are, and they keep changing, they keep adding them every year. They've added probably 10 in the last 5 years. Yeah.
But I've seen you don't even have to list one to get one.
Well, you have
I've seen them issue. They didn't even issue. They didn't even in their petition. They didn't do it.
You're supposed to enumerate a family offense.
Right. So the person knows what was.
Right. So and sometimes they pass through and maybe there isn't one.
Right.
Okay. But if you hire somebody from the get-go that knows these rules, you can go in and ask for an immediate hearing.
Right.
I've gotten dozens of them dismissed first appearance, where I come in and say, Judge, read this thing, you know.
There's no family offense committed.
Yeah.
Right.
You know, there's no drugs, no alcohol. I mean, drugs and alcohol are not a family offense. This is not a family offense.
And everybody, I want you to listen. This is very, very important, because in a custody battle, we call it the silver bullet. People get this to get one person out of the house. And these, you're saying you can get a fast thing. These cases often drag on for German after German. And if you're living without your kids and now you're going into a custody battle, it's hard. First of all, it's very hard to get back into the house if you're kicked out. So you have to do it right. So very important what Mr. Burton just said.
Well, again, you know, it's sort of, you got to watch what you're doing, because attorneys, some of them get paid a flat fee to do it. Other ones charge by the appearance. So you charge by the appearance, you don't have that much of an incentive, okay? All right? You know, I'm very upfront with people, and I tell them, look, I'm going to be there, the one yelling about getting a trial date. You know, I'm going to ask for a trial date as soon as possible.
Big problem, everybody watching.
And as soon as possible means I'm ready.
Ready for trial.
When I walk in, I'm ready for trial. But I've been trying cases since 1980.
I'm telling you, you have to realize how important this is, that you get a fast trial, because the longer it goes on, then there can be, if the person really wants to keep you out, it's very common that they'll call it a violation then. And then that just duplicates your problem, and you may have a violation on a petition that should have been thrown out of court months ago. So you need an attorney.
Yeah, it could be even worse. You could be charged criminally with a criminal contempt. And actually locked up. You know.
So you need to get rid of these. If you can, listen, if you didn't, we're only talking if you didn't commit the offense. You need to hit it, and you need an attorney who says, I will go in there right away and tell the judge, I'm ready to go to trial. And the person who filed it theoretically should be ready every time. They filed the petition. They should be ready for trial right away. Now, there is no speedy trial as far as I'm concerned. No 30-60.
30-30.
30-30. There is nothing like that.
Criminal procedure law 30-30.
Which is sad, because this is quasi-criminal. But from what I understand, the rule is that it has to be heard as soon as possible.
Yes, and yeah.
And you have to tell the judge that. And I've brought into court and said, wait a minute. The judge will say, I'm too busy. I'll say, excuse me, Your Honor. If a woman comes in here today and files for money, you hear that case in 6 weeks. I expect to be treated the same way. And you know what? They usually, when you bring it and push for it, you'll usually get it. If somebody's not seeing their kids.
There are a lot of times there are illegal evictions. That's all they are. You know, you read the petition and it goes along the lines of, he hasn't paid the bills, or you know, people are knocking at the door asking for money. You know, and you learn from that. You know, you really, you learn that, what the real motives are.
Right. So, a lot of the things we're talking about here is just a matter of learning your way. Unfortunately, many people find these things out when it's too late. They signed a consent for an order of protection because they were told it wasn't going to bother them, and now it's haunted them. So, which brings me to my book, if you don't mind. Okay. So, there's a book here, The Web of Family Court, by Mr. Burton's wife, Jeannie Burton. And this is a great book because it just gives you the in and outs of the family court system. You need to educate yourself when you're going into family court, because guess what? The attorneys many times are not going to educate you. You need to educate yourself. Now with the internet, you can read. This is a great book. It's not very expensive. $19.95, probably available on Amazon.com.
All I can tell you is the book is not a how-to-do-it-yourself book. It's more of a what to expect, how to take responsibility, how to move on with your life. Yeah, and basically those kind of lessons.
And it's important that you do things right from the beginning, because many times people make a lot of mistakes. They send the wrong text message to their ex, and it's going to come up and haunt you. I think I read a thing about 60 or 70% of divorces now have Facebook involved. So people bring in Facebook postings, but you need an attorney that works with you to tell you from the beginning, hey, listen, I don't believe you have to be off Facebook because you're getting divorced, but be careful what you post.
Well, getting back to what you said before about the case we had, I mean, I had no idea what the history was. Right. I didn't care what the history was. It was irrelevant. The only issue was whether or not this petition is valid, and whether or not it's just and fair to issue that order of protection. Right. And I didn't make a judgment until I heard the evidence. Right.
But the interesting
lack of evidence.
This thing went on for months again, and if the man would have had an attorney from the beginning that was a criminal attorney that was willing to put that to the judge, it possibly would have been dismissed earlier in the case. Thank God we got the right thing, but it could have gone the other way. Anyway, we are out of time, unfortunately. Again, my guest is Stephen Burton, and my opinion, I've gotten to know him now and read about him. He's got a lot of people know him, and they have a great great things to say about him. So I'd just like you to consider him as somebody you want to speak with if you're going through a divorce and have an order of protection. Hopefully you don't have a criminal issue or DWI, but this would be somebody who is a trial attorney, very important. Stephen, thank you very much for coming on the show. Appreciate it.
Thank you.